That's right, and thank you so much for having me here. My first time in this country and in this beautiful city, in spite of the grey weather. I have to admit that my title was just a trick to sort of get some attention and to get people to stay a love-hate relationship, but it's not entirely untrue though. I think in every long-standing relationship there is an element of hate creeping into the relationship as well. And Denmark is a long-standing member of the European Convention. We were one of the original parties to the convention, and a long-standing democracy as well. And I think that has some effects on our stance towards the convention. I think if you should place me in Denmark in some kind of scale with Germany and the UK, I think we might be somewhere in between. So it's only fitting that I'm the third speaker in this section. Because Denmark takes her international obligations very seriously. So we don't undertake international obligations unless we want to uphold them. On the other hand, being an old democracy and all that, we also take our own culture and tradition seriously. And we also consider ourselves to be a rather well-functioning legal order and democracy. And I think those two, taking things seriously, might sometimes clash. And in my presentation, I'm going to say a few words about Denmark. And if you don't want to hear any more, just raise your hands and I will stop. Because I want to, in the second part, I want to raise some issues for a more general debate. There's been, I think, maybe rightly so, there's been a lot of bashing yesterday and today, a lot of bashing of national governments and national courts. I want to do a little bit Strasbourg bashing to also balance things out a little bit maybe. Okay, a little bit about Denmark. We're a dualist country by tradition. It means that international obligations are not directly applicable in our legal order. But for a long time we've been interpreting our national legislation according to our international obligations. If it's at all possible, we do that. But that's not always enough, as you know, so it might be necessary to incorporate conventions, including the European Convention. But so typical, I think, of the Danish self-confidence maybe, but also our approach to the convention, just like the German one we heard about. We just signed the convention, we just ratified the convention in '53 because we thought it was a good cause. We never imagined it would be relevant to our country, that we should violate the convention. But that was held by the Strasbourg court for the first time in 1989 in the Hauschip case. It's about fair trial. And that was a complete shock to a lot of Danish people. And from that moment on, really, it was decided, well, there is a convention that's relevant to us also. Maybe we need to incorporate it. And so it was incorporated 3 years after with the status of an ordinary law, which means that it's of course below the Constitution, and it's not even above other pieces of legislation. So in principle, Danish Parliament could override if they want to. They can override convention obligations. So far they haven't done so. But they might. Okay, but then looking at how have the Danish courts then applied the European Convention, I think it's fair to say Denmark is one of the best boys in the class. If you look at sort of statistics about violating or not the European Convention, you hardly ever see a judgment where Denmark is found in violation of the Convention. It has happened a few times over the course of history, but I guess it's 12 or 14 cases, none of which are really substantial. A lot of them are about, unreasonable length of proceedings and so on. But that does not necessarily mean, and that was what I also noted before the coffee break, that does not necessarily mean that the convention is a vibrant part of the Danish legal order. I think it's fair to say that the attitude of Danish politicians as well as Danish justices is that this is something that we need to respect. but no more. It's not something that we really like to work with necessarily. It's something that we need to take into account if we don't want Denmark to be badly reflected in Strasbourg and then therefore in Europe. And that's also why it took so long time for Danish courts to take into consideration this convention. You can find absolutely no court decision before 1989 where there is a reference to the European Convention. There is one actually from 1966, but apart from that, there is no one. Okay, I have also looked a little bit into because the Danish courts do apply, of course, the convention. If they didn't, we would be in violation all the time, maybe. But I think it's fair to say that they do not take the convention into consideration in the same way, regardless of the subject matter. I can see a pattern looking through all the cases of the Danish courts that what I would call familiar topics. On familiar topics, Danish courts are much more active, sometimes even proactive, in applying convention standards than they are on unfamiliar topics. Familiar topics would be freedom of the press, freedom of assembly, right to liberty and habeas corpus review, and independence and impartiality of the courts. On those issues, Danish courts seem to feel, okay, here is a convention that is very, very useful because it supplements so very well our own constitution, and we are so familiar with these topics, so we can apply and interpret these standards ourselves. On other unfamiliar and maybe even controversial issues, Danish courts take a very, very cautious stand. I have to say they were also asked to do so when the Danish Parliament incorporated the convention in '92. But just to give you some examples, I mean, on so-called more modern aspects of the right to property, like licenses or even social benefits, Danish courts will be much more hesitant to proactively follow the lead from Strasbourg. They will wait for Parliament to enact those obligations. The same would apply for non-discrimination issues regarding immigration law or regarding also social benefits. And as a third example, which is in the past, that's trade union freedom. Denmark used to be very much, the Danish labor market used to be very much regulated by closed shop agreements, and it tended to function quite well. But then Strasbourg said that, or implied in Young, James and Webster, 1981, that there's a problem if you don't give people the freedom to choose their own trade association. And that was a complete shock to Denmark, but we just wouldn't abolish our closed shop agreements. So we just said, okay, you can interpret this judgment in many ways. So we chose the most narrow one, and then we waited almost, I think, 25 years for Strasbourg to confirm what a lot of us had seen coming, that, okay, it's a principle. This is a principle of negative freedom of association. And so Denmark was found in violation in Sørensen and Rasmussen in 2006, I think it was. Everybody with a sense of human rights could have seen that coming, but the Danish courts would not do it on their own. Okay, this is what I want to say about sort of the general aspects of how Denmark is applying the convention. Now I want to turn to the criticism that has been increasing in recent years, also from Denmark, and that's on one point where I think we're a little bit more like the UK than Germany, that it's become okay to be critical of the Strasbourg Court. There is a populist aspect to that I'm not going to go into, because I think that's not really something we can do anything about in this room, but I want to deal with it in a more legal way, if I can. Something that I think, one aspect of criticism in Denmark, of course, is margin of appreciation and small claims and all that. And we heard about that already yesterday and also today. But I think there is an issue that we haven't talked so much about, and that's the mode of interpretation of the convention. I've heard a lot of people saying, well, then the national system had a problem with receiving this judgment, and maybe it was surprising to them that they could find this result. But there is an increasing, I think, willingness or tolerance towards raising the question of how you interpret, in some cases, I'm not talking about across the board, but on some important issues, does the Strasbourg court take it too far, and does it endanger its own authority and legitimacy by so doing? I think you can raise that question. A lot of those issues that I'm talking about are also issues that are by tradition considered to be very close to national sovereignty, and also the field of politics. That could be something about immigration, but it could also be something about social and economic policy. We heard from the UK the mentioning of the Hearst judgment about prisoners' voting rights. I think it's fair to say, from a Danish tradition of interpretation, I think it's very, very far-reaching to say that you can find in this provision on the right to elections that you can find that UK is in violation. I think it's very, very far-reaching personally, but it's not to spoil the good atmosphere. I want to give you another example, a recent one, where I think every Danish lawyer would agree with the minority in the Strasbourg court. It's a judgment here called, maybe I'm not pronouncing it right, Belaninaci versus Hungary. It's a chamber judgment, and I think it's going to be decided by the Grand Chamber next week, on Tuesday actually, I think. So it's been referred to the Grand Chamber. So this is not a final decision, but still I think it's interesting. It's interesting because it's an example for me of whether this is a fair interpretation of the convention, but it's in a very, very, very important field. It's not just something about somebody was detained for too long. It's a matter of principle, and it's also a matter of huge political importance. What I also noticed, that was actually when I saw the program for this conference and started to think about what is this conference really about, regional challenges. Then I looked at this judgment and I asked myself, well, is there also a different tradition, a different culture of interpretation in Europe? Because maybe it's a coincidence, but the four judges who carry this decision are from the East or Central Europe, and the minority consists of justices from the North or West of Europe. I'm mentioning here the Turkish judge, the Hungarian judge, the Montenegrin judge, and the Lithuanian judge. Kudis, maybe I'm not pronouncing it right. Anyway, and on the other hand, we have the Swiss judge, the Icelandic judge, and the Danish judge. The case is about social benefits and whether or not a government, a parliament, can discontinue social benefits that were previously paid out. In this case, it's about disability pensions. And the applicant in this case had received a disability pension for a few years, and now suddenly the legislation was changed and she no longer fulfilled the criteria to receive this disability pension. And the majority in this decision says this is a violation of the right to property. Maybe I'm not giving all the details. The minority, and including the new Danish, not so new, but the Danish judge, since the last 2 years, Kølbo is his name, they start out their dissenting opinion this way. I'm just going to quote. Article 1 of Protocol number 1 to the Convention, that's the right to property, as you know, has never before today been interpreted by this court as obliging member states to provide persons with a right to social security benefits, independently of their having an assertable right to such a pension under domestic law. We find it flatly inconsistent with the object and purpose of Article 1 of Protocol number 1 to do so. As the right to property under the European Convention on Human Rights is not an autonomous repository for economic and social rights not granted by the member states, we respectfully dissent. And now it's exciting, I'm excited anyway, to see what the Grand Chamber is going to do about this case on Tuesday. I think it can do a lot of damage, at least in Denmark. It can do a lot of damage to the respect of the Strasbourg Court, which has done so many excellent things over the years, if they take it too far on matters that are sensitive, that are traditionally considered politics, and if they don't have a solid basis in the convention text. And I think this is a case where I would say they do not have a solid basis in the convention text. There is no tradition for considering social benefits as property. Okay, this was just also trying to get a new aspect into the debate. I'm sure Denmark is not the only country where there are these kinds of discussions about the limits of the competence of the Strasbourg Court. But thank you very much.